Ladies and gentlemen, welcome. Just wanted to show you that's Marine Zink Delaney. That's her Cleveland, Ohio address. She's an attorney. This is from the clerk of the court. I did a video, $400 billion case update by EeoN. And y'all all saw, sorry, let me get rid of the antics. Ladies and gentlemen, you all saw the document because we showed it on video where the court ordered us to prove that we had served the defendants. Well, what you didn't notice about that I just showed you, go back and look at it. The clerk of the court notified her, but she's not a party of interest because remember, they haven't been served. So why is the clerk notifying somebody who, quote unquote, hasn't been served? So that means she's a plaintiff. But wait, how can she be a plaintiff when she represents the defendants? Oh, let me show y'all something. If y'all don't mind, this is going to the court. We asking fraud upon the court, the general public, and interference with the right to access the court. Sanctions demanded. We're asking for sanctions against Marine. I want to call her something else, but you know we got to be kosher about things. Woo-saw. Sorry, I'm going through this kind of fast. There she is, right there. Ohio. She got, look at that. She got her BS because she's full of it. She's got her JD, you know, because she does a lot of welding. And hold on now. She's admitted. It's called admissions. She's admitted to practice law before the Supreme Court, the District Court of the Northern District of Ohio. Now she's a member of somebody's bar because she is an alcoholic. Okay, and she's a member of another bar because, you know, it's a problem. Now, hold on now. She apparently started her career someplace, and she's been doing this for a long time. A long time, 13 years just about. Shame on her. Ladies and gentlemen, their attorneys at that law firm, they work to protect and preserve business assets for the benefit of their creditors. That's what they do. That's their job. And she's involved in foreclosure services. The name of the law firm is Carlisle Law. I know it doesn't actually spell Carlisle, does it? The S is silent. Shh. What's the issue here? Ladies and gentlemen, have you ever heard of a catch-22? Yeah, it's not where you catch anything. It's just, you know, it's how you kill things. So what happens is the court was saying that they have not been served. Hold on now. Somebody will say, no, the court said they had not been properly served. No, he didn't use the word properly, but even if they use the word properly, it doesn't matter. It's still, they haven't been served. Now, hold on. Let me make sure y'all understand. If they respond, cha-ching, pow, pow, they shoot themselves in the head and the foot. 22. Catching it, they're going to catch both rounds. If they don't respond, pow, pow, they shoot themselves in the head and the foot again. Because the clerk of the court has notified them. Uh-oh. Oh, God, there's another catch-22. Because they've been notified by the clerk of the court. They had a duty to notify the court as to their involvement in the case or their lack thereof, and they didn't do it. Pow, pow, pow. And I don't even like the Second Amendment. But they seem to be loving the 22 situation, so we're going to keep putting them in that 22 position. Okay? Catch-22s are a mother. So this petition is going out shortly regarding this. Oh, by the way, the clerk of the court notifying them? Wait, that clerk of the court ain't supposed to be notifying nobody who's not a party of interest. That's like the clerk of the court notifying every attorney in the district. Well, we have a long-standing policy that we notify such. Well, you need to let us know because we have a right to know whom you're notifying. Just sending us a notice, no, you need to tell us why you're doing that. And why you put it on the plaintiff's side. Uh-huh. Thank you. It's got to be a reason. Got to be. And the only way she could have been notified by the court is she gave them notice of some sort. Haha. That means she had notice of the complaint. And the fact that she had noticed, oh, I'm sorry, I forgot to tell y'all something. Hold on. We got something else in here. It's in big, large letters. See that right there, the case management electronic case filing system? Yeah, when you sign up for that, because it's a judiciary expediency scheme, yeah, they wanted to speed up the process. So I believe it was 1996, they implemented Rule 5 that allowed electronic signatures and electronic services. Sure did. And these guys, all attorneys, must sign up to this program, which means they accept service on behalf of their clients electronically. It's an automatic, mandated thing. The attorneys can't opt out of this program. It is mandatory. If you want to be an officer of the court, you have to sign up for this program. Again, catch 22. I'm sorry. I call myself the presumption killer. Okay, first, presumptions are not allowed in cases at common law. Presumption is not law. It never was. Presumption is a statutory provision, not a lawful provision. You see, the law, common law, is based on facts and conclusions of the law. Statutory provisions are not based on facts and conclusions. They're based on presumptive ideas or thoughts or arguments. That's why the court wants you to argue, because the court's letting you know we're an administrative court. Oh, no, we're not here to argue. Oh, no, this is a common law proceeding. We're here to do facts and conclusions of law. If you don't recognize that, you need to recuse yourself, because that means that you're not allowing us or affording us due process. And I just want to make sure when I say not allowing us, I'm not talking about you have the authority. I'm saying you don't have the authority. Whoo-wee! Just thought I'd explain that to y'all. Now, look, I got to go. Yeah, I know. I was kind of happy because of the position they put me in. They fa-fold. They fa-fold, y'all. The clerk of the court, Zucchini, and Zucchini. Marine, Zinc, Delaney, Zucchini. Anyway, they fa-fold. And so let's see if they can understand the terminology, because I think they're finding out. The rest of you, these documents will be up on the website. We are, like I said, having issues with our website. It's not there now. The website's back up, the old one, but having issues with our website exactly at this moment when we bring this to you guys' attention and invite all of you to join the lawsuit. The court has got no choice. It's going to either have to dismiss it and come up with some reason. So join. There's nothing stopping you. You got somebody who's incarcerated, who had a house, who had a student loan, who had a car loan with the Federal Reserve. Remember the BIC program. I'll be doing a video more than likely either later today or tomorrow, explaining to you guys a little bit more about the BIC program, the borrower in custody program. Okay, you really do. Oh, y'all see that either and either? Either way, there are going to be no claims of lack of notification. The fact is that this attorney, through the electronic email system, has waived their rights, the rights of their clients, in order to participate in this judicious expediency scheme known as blah, blah, blah. And the individual represents clients and the law firm, thereby waiving their rights to service as well. Imagine that. That's me. That's what I do. The presumption killer. So, ladies and gentlemen, you got anybody you know, have them join. All they got to do is fill out the document. The links are under the previous videos. I may be able to attach the link to this video. Either way, there are two places to get it. So we put up the second link. We're going to give you that link in this video. All right. I have to go. I do wish all of you well. And the address is under the video that was done yesterday. The video just before this one. 333 Constitution Way, Northwest, Washington, D.C. 20001. 20001. 3 zeros and a 1. Okay? 20001. It's the zip code. That's the district court. That's where you send the document to. All right? All you have to do is send the document and you're automatically included. Don't worry about a response back from the court. It's not necessary. They are not the parties admitting you to the lawsuit. You see, by allowing you guys, I told you guys this is what I do. By allowing you guys to individually show that you are a party of interest, guess what you did? You made it a class action without us having to ask the court permission to be a class action. Again, another one of those catch-22 things. So there are a lot of people out there saying, I don't know what I'm doing. I don't know nothing about the law. Apparently I know something, huh? Because I'm sitting up here doing all this other stuff to them and just catch-20, shooting themselves in the head and the foot. So they can't even move. Oh, you didn't understand that? Oh, no. See, shooting yourself in the head with a 22, you can survive that. Shooting yourself in the foot with a 22, you're going to be hopping. So, yeah, I want them to be limping. I don't want them thinking that they are free. I'm on the offensive. I will not go on the defensive on behalf of you all. I am on the offensive because they keep offending me. So I might as well sit up here and 22 them. So I'm going to be catching it and they're going to be 22ing, and we're going to see if we can come to a acrimable agreement. What I need for them to do is I need for them to say, we're going to settle this. We're going to make sure that we make right. That's all I want them to do. They just got to make right. They got to make right for all of the people in America. We don't care about the billionaires. I'm not trying to create billionaires with this. I'm trying to make right with this. Everybody who's lost a home, give them a home. Everybody who's lost a car, give them a car of their choice within the same category of what they lost. And we're talking about both homes and cars. Then you're going to compensate them in addition, and they're going to get a Lodio title. No more taxes on their private property, which is a residential property. We can call it a residential property. We can call it a domicile. We can call it an habitation. We can call it a residence. Doesn't matter. None of those words are going to apply in this instance. And we'll make sure of it with the settlement. I'll allow them to do a settlement even though they're in default. I don't have a problem with that, ladies and gentlemen. But I promise you it'll be in your best interest, not mine. Let me say that again. It'll be in your best interest, not mine. You see, that's why I can't tell them what I really think and feel, because I'm now representing your best interest because all of you came into this matter. That's why I won't allow any of you to interfere, put in junk. Okay, this is not yours. So don't sit up here and add what you think should be added because you didn't do this. This was a plan. All of those times that they thought that they were penalizing me and hurting me and locking me up for whatever dumb reason they claim and then releasing me without word, I can't begin to tell you how many times they arrested me and then released me without charges. All to prevent me from telling you guys the stuff I've been telling you. So I'm going to keep doing it, and they're going to keep doing what they do. And guess what? I'm okay with that. But if I got to go through that, you better believe I'm going to plan my attack. I told you I'm on the offensive. This is a plan, so I don't need any of you interfering with it. Okay? I spent days upon months upon years planning. Don't think about Montezuma. Don't think about Monty's. This is mine. With the aid of the God that I serve. Revenge. See, he's allowing me to do this. So that's why I'm being meticulous. That's why I'm systematically picking apart things. Look, this is their downfall. This act that they came up with in 1996. Every attorney opts for electronic service. So after the initial complaint is filed and all the parties are served, after that you don't have to send another notification to any stupid attorney, because every court, including state courts, have this rule that the attorneys must accept electronic process of service to be an officer of the court. So the clerk of the court is the one responsible for serving them. Shh! You're not supposed to know that. So if ever you had a case where the court told you after the initial filing and serving of the summons and complaint, any petition motion after that they claim they didn't receive, they're lying. And get them for perjury. And document the fact that the clerk of the court is the processor server. So the clerk of the court is not a party to the matter. So they can never operate or act as if they are. Shh, don't tell nobody. Like I said, I've been going in and out of court since I was 15 years old, defending myself, not in no criminal case, but in those administrative traffic court cases. Traffic courts are administrative. I had to learn the rules back then. That's how I know this stupid stuff, because I had to study this stuff back then, before there was the internet. I had to go to the library. As a teenager, go to the library, sit in the library, and pick up law books and learn on my own. When I asked other people, half of them didn't know nothing. Except for my father's mechanic, whom a young man who I knew killed. Yeah, for whatever dumb reason. He was a mechanic. That man didn't bother nobody. Taught me the best lesson in my life. Taught me how to repair my own cars by making me, I'm sorry, it's hilarious. Hilarious. Humorous and hilarious at the same time. It's hilarious because he made me pay him to work on my own car. So I had to pay him and do the work myself. And his reasoning was, because if I tell you how to do it, you'll learn. But if teach you how to do it, you'll learn. But if I do it for you, you'll keep coming to people like me and wasting your money when you can do it yourself. And ladies and gentlemen, so I work on my own vehicle. Well, not anymore. I refuse to get oil underneath my nails anymore. Okay, they too precious. So, anywho, ladies and gentlemen, this is what I do. Those of you who want to be a part of this, you come into this with that understanding that you cannot interfere. You didn't invest anything into this. You didn't pay a single dime towards the filing. You didn't pay a single dime towards the mailing. I don't care what you mailed in for yourself. That was your selfish contribution. I'm not doing this for me. I'm doing this for we are the world. We are the children. For everyone else, not myself. What if you live in another country? If you can prove that your loan is directly associated with the Federal Reserve, then you can join this lawsuit if you live in another country. Like I said, they're in a catch-22 situation that they can't get out. Now, the only thing they can do is railroad, and then deny constitutionally secured rights. Do you know the courts have no jurisdiction for denying a party a constitutionally secured right? As I tell it in this, go ahead and say no to any of this, and we demand our evidentiary hearing. See, proof of service. The legal conclusion that the waiver of proof of service through electronic signature receipt of communication by the United States Postal Service is sufficient is supported by several federal rules and precedents. I got to get rid of this second precedent. That's me. I'm adding words in. Okay, so there you go. Oh no, I let them know that I used an AI model. As a matter of fact, give me 1 second. Let's get rid of that S, because that second S right there, it's already in the other one. Precedents and then support. All right, but anyway, let me let y'all know how I told them I was using AI. Y'all gonna believe this? Why, even a language model understands these facts. You know what I'm saying? I'm telling them that I'm now utilizing the technology. This is my paralegal. I don't mind letting them know. Yeah, I'm using AI, mother. And stop me. Show me a law that says I can't use AI. That's my paralegal. You use a paralegal. There's no law telling you who a paralegal can be referred to as or not referred to as. So shut the... I'm sorry. I apologize, ladies and gentlemen. This is me telling you that I have a greater grasp of this than you might have imagined. So please allow me to work. Have a good day, everyone. 20 minutes is all I got for you today. But hopefully you'll pay attention.